recently the Supreme Court issued a ruling that was hailed as a victory for unions, and yet somehow I remain anxious about union rights in this country. And here to help us sort out both that ruling and what it might mean for the future is Lynn Rhinehart. Lynn is co-general counsel for the AFL-CIO, which, if you don't know, is the nation's largest labor federation, representing 56 or made up of 56 affiliated unions, representing 12.5 million working men and women. Lynn, thanks so much for coming on the program.
Glad to be here. Thanks, Richard.
So help us understand a little bit the ruling we just had in the Friedrichs case. First of all, I think it's pretty clear the outcome would have been different if Antonin Scalia were still alive, right?
Well, you never really know until the ruling comes down, but for those of us who sat in the oral arguments in the case in January, it was a pretty discouraging day because it did seem like a number of the justices were prepared to overturn 40 years of precedent and throw out the whole idea of fair share for representation in the public sector.
And tell us what that means, if you would.
Sure. Well, under our legal system, if a majority of workers at a particular workplace vote to form a union, that means that the union is legally obligated to represent everybody at that workplace. And in about half the states, there are laws or negotiated arrangements by which everybody who's covered by and benefits from the collective bargaining agreement and the union's representation of working people pays their fair share toward the cost of that collective bargaining agreement and representation. Fair share is the law in about half the states in the public sector. And what was at stake in the Friedrichs case that was just decided a couple of days ago is whether or not to throw out that whole fair share system and make it really a free rider system nationwide where people could drop out of the union but still get the benefits of representation.
Right, and I just want to make sure that our listeners, all of our listeners, understand this. So what it's really saying is if I work someplace that becomes unionized and our wages go up as a result, and our benefits get better, and everyone voted to unionize in the first place, that I should pay the costs of getting those better benefits and wages along with all my coworkers by paying the same dues they pay, right?
That's right, that everybody pays their fair share toward the benefits of union representation. The better pay, the better benefits, the grievance procedure if somebody runs into a problem at work. Fair share has been the law for 4 decades, and because of the court's ruling the other day, it remains the law of the land today, which we're very happy about. It's a good result, and it's the right result.
So this was something where the case was brought by a right-wing group. It calls itself libertarian. I think of libertarians these days as right-wingers with a vestigial sense of shame. But anyway, there's a group, this libertarian group, Center for Individual Rights, brought the case, and as I understand it, strategized to make sure, asked lower courts to rule against its own clients so they could get a hearing at the Supreme Court, which it presumably felt would be sympathetic to its point of view, right?
That's exactly right. The case got to the court in a very unusual way. The Center for Individual Rights brought the case forward and went to the district court and said, you know what, we know we lose under legal precedent, but so go ahead and rule against us so that we can take our case to the Court of Appeals. And the court did. They went to the Court of Appeals, said the same thing. We know we lose under 40 years of legal precedent. Go ahead and rule against us so we can try to get our case to the Supreme Court. Now, usually, if the precedent is that clear, you don't get your case in front of the Supreme Court. The Supreme Court rejects your case, refuses to hear it, and says, sorry, this is settled law. We don't need to waste our time on this case. And so what was unusual and disturbing about this case is that the court went ahead and took it. The Supreme Court took this case only 2 years after deciding that it was not going to overrule fair share. Only 2 years later, they took the case. And so that was a bad sign of what was on the court's mind and where they were thinking of going here, which is another reason why we were so pleased to see the ruling the other day upholding fair share.
Now, and this was a ruling because the court split 4-4. That means that things stay as they were, and the fair share principle stays in effect everywhere in the country, right?
That's right. Um, with a 4-4 split, what that means is that the ruling of the court below holds, and the ruling of the court below here was it upheld fair share, and that's not surprising because all the courts have upheld fair share. That's been the law for 40 years. So in this case, a tie vote meant a win for fair share, and that remains the law of the land nationwide.
So we're talking with Lynn Rhinehart, who's co-general counsel of the AFL-CIO. Lynn, in my introduction to this segment, I expressed, despite this victory, an ongoing unease about the legal well-being of the union movement and of this principle. Now, I don't have a lot of hard evidence for that, but am I right to be uncomfortable? What are the ongoing threats, if any, to this principle and legal threats to the union movement in general?
Well, I think there's good reason to remain uneasy because the folks who brought the Friedrichs case forward, the Center for Individual Rights, who you mentioned, who are funded by the Koch brothers, and a whole network of other groups, have other cases out there pending, and they have other legislative attacks out there pending to try to weaken unions, to try to attack the idea of working people coming together to make things better at their workplaces. This is just one of a series of attacks that we've seen in the courts, in the state legislatures, in state executive branches. And we know that, notwithstanding the court's ruling the other day, that the Center for Individual Rights and the Koch brothers are not going to go away, and they're going to, unfortunately, keep attacking the right of working people to come together and bargain together for better pay, better benefits, better classroom policies, and so forth. So we do view this as a victory the other day, but we know that the battle is not over, and the groups that really want to take out the labor movement and take out the right of workers to join together, they're not going away.
Yeah, so let's talk just for a minute about a couple of those ongoing threats. First of all, as far as the whole fair share principle is concerned, are these guys going to regroup, hope that they'll get a sympathetic replacement for Antonin Scalia and try to get back to the Supreme Court on this specific principle?
I'm sure that they will be looking for ways to get back to the Supreme Court on this principle. They also have some other legal attacks going against workers forming unions in the public sector that are percolating their way through the courts. Some of those cases will now be moot because of the court's decision in Friedrichs, but some of them will carry on. But yes, I'm sure these groups are very hopeful that somebody other than Barack Obama nominates the next justice to the United States Supreme Court, or the next justice who's confirmed to the United States Supreme Court.
Somebody other than Barack Obama or Hillary Clinton or Bernie Sanders, I would say.
Right, exactly.
What are some of those other? You mentioned that in addition to this specific fair share principle, there were a couple other things percolating their way up the court system. What are those principles?
Well, these same groups that brought the Friedrichs case fighting against fair share have also brought cases to try to just eliminate the whole idea of the union being in the workplace representing everybody. They're attacking the whole idea of exclusive representation, which has been a bedrock of our labor law since labor law began. They're attacking things as silly as they're attacking the right of unions to put information up for their members on bulletin boards in the workplace and arguing that things like that are First Amendment violations. And so there's just any number of other attacks where these groups are trying to undermine the role of the union and the ability of workers to have a union and a strong voice in their workplace.
So let me see, Lynn Rhinehart. So their position is that it is an expression of free speech for an employer to tell his or her employees how to vote, but it is a violation of the principle of free speech for a union to say anything to its members at all.
I guess.
I'm trying to internalize the logic.
I
They
guess.
have to have at least a gloss of logic on their argument, right, in order to get somebody to vote for it, however cynical you are about the process. I'm just trying to decode what their logic could be there.
Yeah, I'm not sure that it rests on logic, but we'll see
Well,
as the cases
I
make their way through the courts. They've been rejected in a number of places, but like I say, we know these attacks are going to continue because there is a very clear agenda behind these attacks. This is a very well-funded operation by the Koch brothers and their allies who really want to try everything they can to go after and weaken unions and weaken workers' ability to come together. The good news is that workers are organizing, workers are mobilizing, workers are, winning. You saw the news about a $15 minimum wage in
Yep.
California, which is just terrific. And so there's a lot of fight back here.
Yeah, no, I think this is a very interesting time. And one last point I wanted to talk with you before we let you go, Lynn Rhinehart of the AFL-CIO, co-general counsel. I just wanted to bring this up because the other party in this case, besides Friedrichs, was the California Teachers Association. And it seems to me in their war on unions, this billionaire-funded war on unions we're all struggling with here, that they seem to single out teachers. There seems to be a kind of demonization. My mother was a teacher. I grew up around teachers. I was a teacher myself for a year coming out of college, 2 years. But, it seems to me like as if there's a demonization of public employees in general, as if somehow a public employee with a decent retirement plan is the reason why our economy is struggling, why millions of people are struggling, as opposed to wealth inequality. And teachers in particular. And I just wondering, I know your general counsel, but I wonder if you have any observations about this process of, in order to win their fights, demonizing public employees in general and teachers in particular.
I agree with you that it's a little counterintuitive to pick teachers as your villain, the people who teach our children and who have formed unions at their workplaces to address things like classroom sizes and supplies in the schools. And when you're attacking teachers and firefighters and police officers and the people who provide the basic public services to all of us, it really it really, it bothers us that these are the sorts of people that the right wing is going after. The rights of folks who provide us our very basic services to have a voice on the job. So I agree. They're, really, it's unfortunate they've decided to villainize this group of folks who work so hard and do so much for all of us.
Yeah, it's certainly my feeling. And listen, we're glad you guys are out there working on these issues and representing working people on these issues. I think it's so important, and I think that working people in the media these days don't get nearly enough of a hearing, and we will want to do our small part in redressing that as well. So, Lynn Rhinehart, co-general counsel of the AFL-CIO, thanks so much for coming on the program.
Thank you. My pleasure.